Just test.
Good afternoon.
Sit down. Because with four of us, it just seems, unless Chris wants us to stand. You can just stand? Well, if the people before me stand, I'll
Welcome
stand.
to the second program and public law event of the fall. This is an occasion to learn about some of the pending cases before the Supreme Court this term. We have a distinguished panel of Professors Siegel, Mosteller, and Chemerinsky, and myself, who will describe some of the significant decisions for you and try to leave ample time for questions at the end of the hour. This is the first term in the last dozen that the court has a different composition. We've just finished a period beginning with Justice Breyer's appointment in 1994 until this past term when the court's composition remained the same. So there's a lot of speculation about what the impact of Chief Justice Roberts and Associate Justice Alito will have on decisions, and we may have a little speculation about that in addition to a discussion of the cases as we go along, but I think we'll probably be occupying the bulk of these introductory remarks, simply giving you an overview of some of the significant litigation. The court's taken about 28 or 29 cases, depending on how you count. They usually hear between 70 and 80.
The nature of a guide. Here you have punitive damages 100 times the size of the compensatory damages. Does that violate due process? Also, Philip Morris is making an interesting argument here. They're saying punitive damages should only be to punish a defendant for the conduct that was directed at that plaintiff. That punitive damages shouldn't be to punish the defendant for more general wrongdoing in society. If the Supreme Court would accept that as a constitutional matter, that would end punitive damages as we know it, because punitive damages have always largely been about deterring wrongful behavior. And whether the Supreme Court's willing to go that far could have a dramatic effect on the law as well. So two different areas, but both of which I think give us some sense of where's the Roberts Court going.
Okay. I'm Bob Mosteller. I'm going to be talking about one case, Wharton versus Bochting, which is a retroactivity case about the Confrontation Clause. And what's retroactivity? Basically, in criminal cases, when the court decides a new rule, that the litigant in that case gets the benefit of it. Retroactivity is asking how many people whose cases have been tried earlier, who are in prison right now, get the benefit. A totally prospective rule would be one that applied to this litigant and police conduct or prosecutorial conduct after that point. A totally retroactive application would be as to everybody who's still suffering penalties as a result of a prior adjudication on this same issue. The Supreme Court basically divided the world into two parts. All those cases that are on direct review, as long as your trial is not final, as long as you're in the appellate system, you get the benefit of a new ruling. With respect to those that are after they're final on what would be called collateral attack and the person's in prison, generally not, but with some exceptions. So what's the case at hand about? It is a case out of Nevada, and it's just an ordinary state case. It is a child sexual abuse case in which the defendant was charged with doing several vile sexual acts to his 6-year-old stepdaughter. It involved hearsay and confrontation, so many of you haven't had evidence. What's hearsay? Well, I can explain it in terms of what the example. The police officer gets on the stand, and the police officers ask what he knows about it. He says, well, I know what the little girl told me. And so is asked, what did the little girl tell you? And the officer recounts the detail. The defendant objects hearsay. That's her out-of-court statement coming in to prove that I did it. And one of the things about confrontation is often people throw in the constitutional claim, because you might as well, and it was in fact the more significant one here. And while I'm at it, I'm going to object on confrontation clause grounds. That's very important, because you can't benefit from a new rule as a general matter unless you objected to it when it came in in the trial court anyway. So he objects on the basis of hearsay and confrontation. The child has become unresponsive and doesn't get on the stand. So he cannot cross-examine the child. The state of Nevada has an exception that allows hearsay to come in this kind of situation if it has what they call indicia of reliability. Not a real clear issue. They work around on it for a period of time, and he loses in the state courts, okay? He's got very little chance in the federal courts at that point, but 2004, March 2004, the Supreme Court dramatically changes confrontation clause law. They decide a case called Crawford versus Washington. And in that case, in an opinion written by Justice Scalia, which is a very much an originalist style opinion, he looks at history, he pulls out his dictionary and looks at the word witness in the Constitution. For him, witness means someone who gives testimony. He derives the testimonial statement definition, and he really trashes the system that existed before that point, Ohio versus Roberts. If I'm psychoanalyzing, he wants it to go away entirely, but he quite makes fun of it, and it is based upon exactly what they did in this case, and that's to look at the indicia of reliability, and if the judge finds it has indicia of reliability, it satisfies the confrontation clause. The theory is you don't need to confront to ask questions of someone who made a trustworthy statement. Scalia's best lines, I think, in the Crawford opinion are the following. Dispensing with confrontation because testimony is obviously reliable is akin to dispensing with the jury trial because the defendant is obviously guilty. This is not what the Sixth Amendment prescribes. So he says that, and that applies, that testimonial statement fits this kind of a statement. And if you've got a testimonial statement, the basic point is you either get to cross-examine, you get to confront, or it's inadmissible. He wins under the new regime. The problem is this is not on direct review. This is on collateral attack. It's final. It's final. So what are our exceptions? What are our exceptions? That basically, first of all, the court needs to decide whether or not it's a new rule or not. What do I mean by that? If you simply apply the same principle of law to a very similar set of facts as the last case, that is not considered retroactive. That's basically applying the law to a simple, straightforward set of facts. Okay. But so, first of all, is this a new rule? Is Crawford a new rule? Most people would say it is. I'll suggest that there may be an interpretation that it isn't. And then if it is a new rule and you're on collateral attack, you can only succeed if you satisfy one of two exceptions. The first is, it comes out of Teague versus Lane. It is that this ruling puts beyond the scope of criminal punishment or criminal law certain kinds of activity. This case doesn't fit within that exception. The kind of example would be when the Supreme Court decided people below 17 couldn't be executed. Everybody who was on the way to execution who was 16 benefited from it because they could no longer be punished. He doesn't fit in that category. He's got to fit in the category that is basically a watershed ruling that affects the fairness of the outcome. The problem with that exception is once you get there, they never find it. And they've basically said in a recent case is, we doubt there are any more of these out there. We doubt there are any more of these out there. Conceptually, it could be, but and sometimes it's compared with a ruling that would be as big a blockbuster as Gideon versus Wainwright, having to do with jury trial. Right to counsel before you would prevail. So, as a general matter, the petitioner in this case, the defendant in this case, the person who's in prison, who won below, is basically the respondent in this case, has a tough row to hoe, and every other circuit has held against the position by the Ninth Circuit. And so there's an array of circuits against it, and so it seems unlikely they'll prevail. One of the situations is he might actually have the exception. because this is the right to be able to cross-examine somebody, and there's an argument you can have that that's just procedural and not going to the accuracy of the outcome, not going to fairness, but he might well be that one rare blockbuster that fits. He's got every other court that's decided against it, and he's got another thing that's against him, is they just can't do this as a practical matter. It just affects too many people. We have, 2 million people in jail right now. Over 1 million of them would have been convicted under the regime in which Ohio versus Roberts, the old system, was in play. Lots of those people, their convictions wouldn't be affected because they pled guilty. But there are a lot of people whose convictions would be affected, and as I mentioned, lots of those people actually did object on confrontation clause grounds at the time. It applies to state, federal, it applies to murder cases, it applies to all sorts of cases. I don't know what the numbers would be, but they could be substantial. So as a practical matter, it's hard to see how he could win. The kind of joker in this is, and I alluded to it earlier, is this a new rule? And it's kind of a quirkiness of Scalia. The thing that this person may have going for him is Scalia really believes in Crawford. That he wrote that opinion, he wrote the follow-up opinion, he was able to command a 7-2 majority for the first, an 8-1 majority for the second. He really hates Roberts, and he believes in originalism. How might this come back in a way? One of the concurring judges in the Ninth Circuit, his Ninth Circuit 2-1 decision, said this isn't a new rule. Why? Because this has always been the law. That this is not a new rule because these are basic principles that have always been there. I doubt Scalia will do it, but it wouldn't surprise me if Scalia would write an opinion about the originalism of retroactivity. And it was the case prior to the point that the Warren Court started developing all these criminal law rights. There was this principle that all opinions were always retroactive. Why was that? The law was not invented by judges. Judges just applied the law, just found the law that had always existed. When we got to the Warren Court era, nobody could really do that with a straight face. Nobody could basically say that with a straight face. Scalia is actually saying that about about Crawford. He is saying this is what Confrontation Clause meant at the time of the framing. It's been what Confrontation Clause meant from that point until this point. Ohio versus Roberts, the old regime got it completely wrong. And it would really be a strange ruling, but he could at least write an interesting dissent. And my guess, and Erwin and I have talked about this, we both believe that it can't go in favor of the prisoner, but it might well be a situation where the 7-2, 8-1 consensus on Crawford and how important it is may break apart. And it wouldn't surprise me if Scalia does something relatively unusual for him, and that's to not only side with, but very much champion the position of the person who's locked up.
Thanks, Bob. I'm going to tell you briefly about 1.5 cases. The half case is one that involves our own local energy company, the Duke Energy Company, which was sued in 1999 just as the Clinton administration was getting ready to fold up its tents for violating a regulation under the Clean Air Act that had been written back in 1980 that essentially required power plants, when they modified their physical facilities, to install state-of-the-art pollution control equipment. And the allegation was that in each and every one of Duke Energy's coal-fired power plants, it had engaged over the years since 1980 in modifications of those generators and turbines that should have resulted in state-of-the-art control technology being installed, and they weren't. The Bush administration comes into office and takes a very different view of this 1980 regulation, and in fact institutes administrative law proceedings to change it, and actually had to think long and hard internally about what it was going to do with this pending litigation, and not just involving Duke Energy, but a couple of dozen other utility companies around the country. It eventually decides that it's going to continue to prosecute them but not institute any new actions. And so this is an enforcement action here in North Carolina, brought by a somewhat reluctant suitor, the United States, against the local power company. And in a preliminary ruling, the district court rules in favor of Duke Energy in a way that results in the government saying, well, if that's the ruling, I'm going to concede all of the other contested facts in the case for purposes of making this a final judgment so that I can appeal it. They go up to the Fourth Circuit and lose, and at that point, the United States is content, would just settle, collect its losses and go home. But two environmental groups had intervened in the litigation, and they decide they're going to petition for certiorari to the Supreme Court, whereupon on the side of the United States against the energy company, but on their own behalf as interveners. The United States files a opposition to this request. Don't help me, I'm doing fine losing on my own. It's essentially the position they take. And lo and behold, the court takes the case over the opposition of the United States. This is actually the first case the court's ever taken that's been brought solely by environmental organizations on appeal. And to boot, the United States is in opposition at the cert stage. Once cert was granted, the United States has now changed its position, and it's filed its merits brief reads, brief of federal respondent in support of petitioner. It makes a very interesting, procedurally postured case. Now, the environmental organizations don't know quite what to make of this chain of events. In general, environmental groups sort of break out into cold sweat when the Supreme Court takes one of their cases because it's not a very environmentally friendly venue, although the groups frequently end up doing somewhat better than their worst case prediction. It's not a step that they take lightly, and they decided to appeal this one because they thought since this was the first Court of Appeals decision on an issue that's being replicated in district courts throughout the country, they might as well take a shot at fighting this one and see what their prospects were going to be. It's actually a very interesting example, and the reason I'm just telling you about half of it and not getting you into the nitty-gritty of the Clean Air Act is to make the point that it's a very interesting exercise in advocacy because the petition filed by the environmental groups elevates to front stage in the litigation what looks like a garden variety and kind of dry question of administrative law. And it relates to the fact the Clean Air Act has a provision in it that says only the D.C. Circuit Court of Appeals can be the venue for reviewing regulations of nationwide applicability. And so you can't, as somebody in a Duke Energy posture being sued in an enforcement action, challenge the validity of this 1980 regulation in the enforcement action here in North Carolina. You had to have done that 26 years ago in the D.C. Circuit when the 1980 regulations came out. And most people who've been close to this case think it was the ability of the environmental groups to craft the case as an important question of intra-circuit division of labor, because there are lots of these provisions that isolate the D.C. Circuit as the sole federal venue for hearing complicated administrative law cases in other statutes, environmental statutes, but other kinds of statutes as well. And so being able to craft the case as one that involved a kind of neutral environmental principle of some importance, they think that's the reason that the court might have entertained the notion of hearing it and ultimately decided to hear it. Having the case taken then, of course, led to a lot of consternation from the environmental groups, all in the nature of being careful what you wish for, because they're all concerned about the court getting to the outcome on the merits and that not being desirable. But as I say, they decided that this was the shot they had to take, and through a very interesting advocacy decision on the part of the environmental groups, who usually like to drumbeat the environmental significance of what they are doing, but downplayed it considerably here. There's some good informed speculation, I think, that was a contributing factor in the court taking the case. The other case I will tell you about is Massachusetts versus EPA. This is a case in which the environmental consequences of the decision are being trumpeted. This is a global warming case. And there are a number of these in different postures around the country and in some international tribunals, as people who are frustrated about the lack of legislative and executive progress on the global warming issue are doing what such people have always done in our country. They're trying to find ways to bring this action into the courts. And they're also importuning state governments to take action, and some states have taken fairly aggressive actions at the state level, California, Massachusetts, New York, and some others, instituting their own local level responses to global warming. This case involves a national question, though. It involves the question of whether, under language that was written back in 1977, before global warming existed, or before we knew it existed, the EPA has the regulatory authority to regulate carbon dioxide coming out of our auto exhausts on the basis of its impact on the global environment. And it's an interesting statutory interpretation question, because if you look at the language of the statute, there can't be any question about what the answer is. Yes, the EPA has jurisdiction to hear this case. The language that's at issue is language that says the EPA can regulate auto emissions, contents of auto emissions that may reasonably be anticipated to adversely affect the public health or welfare. And then if you look at another portion of the statute, welfare is defined to include climate. So the argument is carbon dioxide is the major greenhouse gas. It contributes to global warming. Global warming is, on the basis of a near scientific consensus now, affecting the global climate, QED. Nonetheless, the Court of Appeals in the District of Columbia concluded that, in fact, carbon dioxide was not covered by this statutory language, even though I think any plain meaning advocate would conclude that it had to be covered. And the reason there is some room for play in the joints and disagreement is because of a case the court decided back in the 1990s called Brown and Williamson versus FDA, in which there the issue was whether the Food and Drug Administration had regulatory jurisdiction to regulate tobacco. And if you looked at the FDA statute, it was just as crystal clear that the FDA had jurisdiction to regulate tobacco, since the operative language was you can regulate substances that are marketed and intentionally affect the function, the nature and function of the human body. And nevertheless, the court decided that FDA lacked jurisdiction in that case by a 5-4 decision. They reached the tobacco decision because there had been 60 years of history of FDA commissioners and secretaries of Health, Education, and Welfare, and Health and Human Services traipsing up to Congress and testifying before various committees that, of course, the FDA did not have jurisdiction over tobacco. And in the face of the further fact that Congress had enacted at least half a dozen statutes that did things like regulate advertising of tobacco that were clearly predicated on the belief that tobacco was a product that could continue to be marketed without FDA regulatory heavy-handedness. And these and some other contextual facts persuaded the court that Congress had clearly spoken to the issue, even though if you looked at the statute that you would first go to look at, it clearly covered tobacco. The same kind of argument is being made in the global warming case, but on the basis of a far lighter pattern of inconsistent administrative and executive branch activities. In fact, the only official position of the EPA prior to this litigation was one that the General Counsel of the Clinton administration took in 1998, in which he concluded in response to this precise legal question being asked that EPA did have jurisdiction over carbon dioxide. And that actually was what formed the basis of a petition brought by the state of Massachusetts and some other states to say, in effect, to EPA, well, you say you have jurisdiction to regulate, now do something about it. And it was in response to that request to do something about it that the Bush administration's EPA changed its position on the legal question. Brown and Williamson has become a pretty important administrative law case, and because it's opened the opportunity for lots of creative argumentation that tends to ignore the explicit language that Congress has written. And that cert petition was couched very much in terms of and interest that the court ought to have in preventing the lower courts from just taking Brown and Williamson, which I do think the Supreme Court saw as a kind of sui generis fact pattern, and turning it into a massive principle that allows lots of creative lawyering to avoid statutory meaning, and that would therefore shift a lot of authority away from Congress, who wrote this relatively comprehensible and understandable language, over to administrative agencies who could make pretty much whatever they wanted to of it if given enough room to argue under the Brown and Williamson principle. So it's a brief survey, I think, of some of the, not all of the interesting cases, but some of the interesting cases that before the court, and let's throw it open for discussion or questions from anyone for a few minutes before we adjourn. Yes?
I have a question for Professor Siegel, that if the court were to come out in these cases, Seattle and Jefferson County, against the plans, what impact, well, in the reasoning, what impact do you think that Gratz and Grutter would have on that? And then if they came out against it, what would that overrule Gratz and Grutter? And because it's only been 3 years since those other decisions, what impact would that have on criticisms of the court of just making it up to suit their political whims?
It's a very good question, and I think the answer, fortunately, or maybe fortunately, is that it depends. The first thing it depends on is how the court invalidates these plans, assuming they do. If they say across the board any race consciousness in student assignments is unconstitutional because it never advances a compelling state interest, so that the only way we can have integrated public schools is through a court-ordered desegregation remedy, right? Then you're talking about, I think, serious tension with, at least with Grutter, although not completely irreconcilable. I'd be very, very surprised if the court used this opportunity to revisit Grutter and Gratz, because I do think the context is so distinct, and all the courts below, however they feel about this, in majority or in dissent, are all saying that it's distinct. Right? That in fact, Grutter, the dissenters in the Ninth Circuit are saying is that Grutter dealt with genuine diversity. This is just racial diversity. So I don't think the court is going to go to Grutter and Gratz, but I do think, depending on how they decide these cases, they could put a lot of stress on the reasoning that supports the outcome in Grutter. If you care about racial healing, racial understanding, leadership, right, professionalism, civics, right, to say that it applies only in elite universities where a very small percentage of the population goes, but has no applicability in public school districts around the country, when we've said for a long time, we the court, that schools are sites of cultural reproduction, right? That would seem to be hard to square, but the court has done that and more in the past.
Can I add this, Chris?
Sure.
This goes to the theme that I put here. Especially for those of your first years, it was in Grutter versus Bollinger in June of 2003 that the Supreme Court held 5-4 that colleges and universities have a compelling interest in a diverse student body and therefore may use race as one fact among many in admissions decisions to enhance diversity to benefit minorities. Justice O'Connor wrote the opinion for the court there, joined by Justice Stevens, Justice Souter, Justice Ginsburg, and Justice Breyer. Justice Kennedy dissented there. And in fact, in the time Justice Kennedy has been on the court, 20 years now, he has never voted to uphold any affirmative action plan. Many think, therefore, that there may now be 5 votes to overrule Grutter: Roberts, Scalia, Kennedy, Thomas, and Alito. And in fact, if you look at the questions presented in these cases, one of them actually raises the issue of whether Grutter should be overruled. I agree with Neil. I don't think the court is likely to, in this case, take on Grutter directly. But I do think what the court says here well could indicate whether there are 5 votes to overrule Grutter, whether Grutter is likely to survive. And again, it goes to something that I talked about is, well, what's going to be the attitude of the Roberts Court towards precedent, even very recent precedent?
Yes.
I have a question to Professor Mosteller. Do you foresee that the courts in some way would ask the trial level courts to be more quasi-inquisitorial in their process as a result of any possible diminish of cross-examination?
That they've cast them, or they want them to be, or what?
Do you believe that there would be any progress towards a requirement for courts in criminal trial levels to be more quasi-inquisitorial?
It'd be heading in another direction. I mean, if there's any movement right now, that is the evil. And when Scalia talks about what were the framers really most against, they were against the civil trial method, the inquisitorial system. So Crawford is basically a blow against any movement in that direction, and it was just make that our whether or not confrontation makes a lot of difference. That's what the framers believed in. That was the form and the revered common law method.
Yes.
For Professor Chemerinsky, with regard to the upcoming abortion cases, I'm curious what your thought is with regard to the evolution in Kennedy's line of thinking with regard to the right to privacy, because in Lawrence v. Texas, he really, came down strong on the side of privacy, much to many of our surprise.
I'm going to talk a bit about, answer your question, Justice Kennedy as to abortion and his evolution there, and then tie it to Lawrence and privacy. Because Justice Kennedy has taken a number of different positions on the court with regard to abortion. And let me explain why this is so important. That if you accept what I think is the conventional wisdom, that there are 4 votes to overrule Roe in Roberts, Scalia, Thomas, and Alito, the survival of Roe versus Wade with these 9 justices depends on Anthony Kennedy. Justice Kennedy first participated in an abortion case in 1989 in a case called Webster versus Reproductive Health Services. And there, Justice Kennedy joined an opinion by Chief Justice Rehnquist urging the overruling of Roe versus Wade. It was an opinion by Rehnquist and White, and they were the only 2 dissenters in Roe, which was a 7-2 decision. However, when the Supreme Court then next considered abortion in 1992 in Planned Parenthood versus Casey, Justice Kennedy was one of 5 who voted to reaffirm Roe. We know now, thanks to Linda Greenhouse's book, Becoming Mr. Justice Blackmun, when the justices first voted in conference in Casey, Justice Kennedy voted for the 5th vote to overrule Roe versus Wade. But sometime between when the justices met in their conference and privately voted, when the decision was publicly revealed, Justice Kennedy changed his mind and joined the other 4 justices to reaffirm Roe versus Wade. Well, in 2000, in the case I mentioned, Stenberg versus Carhart, Justice Kennedy writes a vehement dissent saying the Nebraska law should be upheld, that he never imagined when he joined the majority in Casey that this is what it would be used for. So just on the abortion issue, Justice Kennedy has been on all sides, and so there's a real sense of, well, where is he going to be now when he is the deciding vote? You're quite right. In 2000, in a case called Lawrence versus Texas, Justice Kennedy wrote for the court in striking down a Texas law to prohibit private, consensual, same-sex sexual behavior. He wrote a very eloquent opinion about the right to privacy, and it including the right to engage in homosexual activity. But what that means with regard to his views on abortion, we don't know.
Can I say something briefly?
Yeah, go ahead.
Yeah. Just answer the question briefly and directly. I think for Justice Kennedy, abortion is very different than the privacy interests at stake when it comes to homosexuality. Right? In the context of Lawrence or Romer before Lawrence, which really previewed Lawrence, he doesn't see anything on the other side of the table. He doesn't see anything but state-mandated bigotry. Right? That's what he thinks the state interest is, if you read his opinions and his emphasis on words like animus and demeaning. In the abortion context, I think he sees it very differently, that in fact there are substantial interests on the other side. And one might also look across the Atlantic to Europe, in which there is much more explicit, robust protection of privacy rights in the constitutions of various states in Europe, and yet much more restrictions on abortion than exists in this country. So I think people see privacy differently in that context, or at least they may.
Yes.
What's a good under-the-radar case to go up to D.C. and watch? I mean, for instance, it'd be great to go watch these abortion cases, but they're going to be lining up 2 weeks in advance to see that.
I have a nominee. One of my favorites of the year is a case called Kerry Musladin versus Mrs. Musladin. It's Musladin. It involves a situation where a woman was tragically murdered. Her family came to the court during trial and wore buttons with her picture on it that the jury could see. And the Ninth Circuit said for the victim's family to wear buttons with her picture denied the defendant due process in a fair trial. There's some other procedural issues in the case, but I think it's a really interesting case about free speech rights versus defendants' rights to a fair trial.
Yes, sir.
The peculiarity of the American system is the punitive damage in relationship with compensatory damage. I was hoping that all 4 panelists would elucidate some more of the bright side rule and how, where this rule stands given the fact that we are governed versus boards and unbiased
want to take that one, Erwin?
Sure. As I said earlier, the court had
The
never...
question is what the status of the jurisprudence on punitive damages, excessive punitive damages, is right now.
The court had never invalidated a punitive damages award as being unconstitutional until BMW versus Gore in 1996. And then they didn't overrule, but instead built upon BMW in State Farm versus Campbell. In fact, the court articulated a three-part test for trying to decide whether or not punitive damages are unconstitutional. Judges and lawyers love three-part tests. It makes it look really precise when punitive damage is unconstitutional. And I think that the Philip Morris versus Williams case is going to be important in clarifying the test, giving guidance to lower courts, but also because 2 of the 6 justices from the majority in State Farm, 2 of the 5 justices from the majority in BMW are no longer on the court, because this is an area where ideology doesn't predict what justices are going to do. We could see a major change in the law with regard to punitive damages in Philip Morris.
I don't have any.
I'll just add one more point about this punitive damage area. It's not an area where ideology classically defined cuts very deeply. It is an area the business community, which is one substantial component of the Republican coalition, cares a lot about. And actually, members of that community were quite aghast when it became apparent that 2 of their stalwarts, Justice Scalia and Justice Thomas, actually had very, from their perspective, anti-business perspectives on the punitive damage issue, which is essentially it's not a question for the Supreme Court to place limitations on. So there was a lot of speculation in the business-related legal community when the nominees for the court were going through the White House as to whether the nominees would be more business-friendly, friendly on the business issues. People, I'm told, were very happy with Justice Roberts' nomination, Chief Justice Roberts. He had a long-time history of representing corporate clients, and people thought he understood the corporate issues and was sympathetic to the business perspective. There was general happiness with Justice Alito, not quite the same level, because he hadn't come out of a corporate law kind of practice, but his opinion seemed to indicate that when confronted with cases in, say, the employment discrimination area, he again was somebody who was going to be more understanding of the business perspective. So the punitives case that is up is going to, another one of these bellwether cases for figuring out where these justices are, is going to be a case that the business community is going to look at very attentively to see whether the bets they placed on the Chief Justice and Justice Alito were actually well put or not. So there'll be a lot of interest in that case for that reason. Yeah, one more and then we'll go.
Professor Schroeder, I have a question about Massachusetts versus EPA. What the impact of ruling either way would be. And the reason I said is they're just, if I understand right, it's sort of a procedural one. They're deciding whether they have the authority to, not whether they have to. Just if they don't, they have to justify it. And I may be misunderstanding it. But I'm wondering what is at stake, and if you have any thoughts or insights on how you think the different justices might line up on it.
Yeah. Practical impact within the Clean Air Act regime is a split-level question. One is, if it were established that the carbon dioxide was a covered pollutant under the Clean Air Act, that would trigger a number of what are called non-discretionary duties that the EPA has. That once they have been forced into a corner to admit something satisfies the definition of a pollutant, and also on the basis of their own documents concede that it affects the general welfare, then they would at least have to engage in the exercise of deciding how and whether it ought to be regulated. At that level of deciding how it ought to be regulated, they might effectively neuter the opinion by deciding that it wasn't something they could regulate very effectively now, and there are ways in this complex statute to defer doing things that are excessively expensive or for which the technology isn't reasonably available at the moment. So it's only one step in down the road. It might not be a very big step in ultimately getting some regulation out of EPA. Its legal/political significance, I think, would be much broader in that it would be a recognition that the science has moved sufficiently far so that you can't deny any longer that global warming is a substantial problem, and that there are legal authorities to do some regulation of it, which might prompt a change in the balance of political arguments as to whether standalone global warming legislation ought to be enacted by Congress. If you could create a reasonable fear that something draconian was going to happen under the Clean Air Act, I'm sure that would stimulate Congress to try to craft some more moderate, but still better than what we have now, regulatory approach. So I think it's being used as a case that, with the expectation, if it's successful, that its political momentum would be as important as anything that came from it immediately as a legal matter. And as to predicting the outcome, it's quite likely this case never reaches the merits. There's a substantial issue of whether the plaintiffs have standing to sue in the case, which was slid over in a very interesting way by the three-judge panel. Judge Randolph, who wrote the opinion, said, well, there's enough in effect, said there's enough in the affidavit so that you could find standing, but I think there's substantial questions about standing, but I'm going to overlook them so I can get to the merits. Judge Sentell said, there ain't no standing. And then Judge Tatel, he said, but as long as my brethren are going to reach the issue, I'm going to decide with Randolph. And then Judge Tatel dissented on the merits and thought there was standing. The problem with there being standing is a problem that it's very difficult to connect any particular thing that EPA could do in regulating auto emissions that would have a traceable impact on global warming, say in the state of Massachusetts, which is one of the plaintiffs, or the state of New York. So it's quite likely that for all of the publicity about it as a global warming case, that it ends up being a standing decision and the plaintiffs are tossed out on standing grounds. And with that, I think I will thank you all for coming and thank our panelists.